So does a debt collection letter have to tell you who the current creditor is? Or can it be kind of vague or ambiguous? Well, that's what we're going to look at in this case. This is the Stefik versus Client Services out of the Seventh Circuit, and this was decided a couple years ago in 2020. I want you to see this for a couple reasons. One, just to literally learn this part of the law under the FDCPA, Fair Debt Collection Practices Act, about what a collector has to do when it notifies you about the debt. Does it have to tell you the name of the current creditor? And the answer is yes. And then also I want you just to see kind of the court's thinking and reasoning in this. And I'll say this, sort of by reputation, the Seventh Circuit is not very consumer friendly. And this is a case where the trial judge, the district court judge, threw the case out. The Seventh Circuit looks at it and they reversed it and said, not only should the defendant, debt collector, not have won, but we're telling the district court enter judgment on behalf of the plaintiff, the consumer. So pretty interesting how we get there. All right, so let's look at this. And we'll start down here. This is under 15 U.S.C. section 1692. That's just the FDCPA in general. And then GA2 says there's a written notice, and it has to contain a number of things, including the name of the creditor to whom the debt is owed. All right. So what happens? This letter has a portion of the letter that says this is regarding Chase Bank USA, and then it gives an account number. And then it says here's who you can pay, which is Client Services, the debt collector. It did not say whether Chase Bank still owned the accounts in question or instead had sold the debts to another entity. So there's a lawsuit filed. The court said, well, I find Chase Bank is actually the current creditor. There's a little bit of dispute over who the current creditor was, but the court said, you know what, Chase Bank is a creditor. And so I'm granting summary judgment in favor of the debt collector, Client Services. This is what the district court or the trial judge did. But then the appellate court says the actual identity does not control. Regardless of who then owned the debts, the question under the statute is whether the letters identify the then current creditor clearly enough that an unsophisticated consumer could identify it without guesswork. So remember what the law says. You have to say the name of the creditor. And the court's saying it's not just a matter of, who the creditor is, but as a debt collector, have you explained that clearly? Or are you making this confusing or vague here? And it says the undisputed facts show the notices here failed that test. Therefore, we reverse and remand for entry of summary judgment in the plaintiff, that's the consumer's, favor. All right, so here's what happened. There were a number of agreements between the parties, and then there was a little bit of a change by the debt collector, and so that's part of the opinion. We won't really focus on that. But they agreed Client Services is a debt collector, the consumers are the plaintiffs are consumers, and the communications were these letters that they were communications in an attempt to collect the debt. So in other words, all the elements of the FDCPA are satisfied. Now we're just looking to see, well, given all that, are the letters compliant or defective? What's the answer? And so here's the letter. You see Chase Bank up here. There's an account number. And then this is standard language, notify our office within 30 days. And then it says payment should be made to Client Services. There's a P.O. box. That's Client Services in Missouri. And then it has what's called the mini Miranda. This is from a debt collector. Any information obtained will be used for that purpose. So let's see here. The district court grants summary judgment finding the letters contain the name of Chase Bank and no other creditor. Judge goes, see, they satisfied. They told you it was Chase Bank, and that's the only creditor. And the appeal happens, and the court says, well, you did not identify the current creditor. So how does the FDCPA work? Well, it protects consumers through some disclosure requirements. Now, it also forbids or prohibits certain type of abusive conduct. But in this lawsuit, it's really all about the information. So when a debt collector communicates with a consumer, at least in this one communication, it must tell the consumer who the original creditor is. And that's part of the protection you get as a consumer. And so the required notice, this under 1692G, sometimes called validation or verification. So we have to be told the amount of the debt, name of the creditor. If you dispute within 30 days, or if you don't dispute, we'll assume it's valid. If you dispute in writing, you get certain things. But this is our key, the name of the creditor. So now the court's going to say, before we get into the details, let's just sort of remind ourselves of what we say the law is about disclosures. So these mandatory disclosures have to be made so they be clearly understood by unsophisticated debtors. So it's also called unsophisticated consumers. This is similar. It's not exactly the same, but very similar to what the 11th Circuit, where I practice, which is Alabama, Georgia, Florida, what the 11th Circuit and other courts typically call the least sophisticated consumer. Here, the 7th Circuit calls them unsophisticated debtors or consumers. Very similar here. And so it says, look, it's got to be clearly understood by them. So you can't defeat the purpose, which what's the purpose? The purpose is to disclose information to an unsophisticated consumer. You can't defeat that by making the disclosures where they're unlikely to be understood. And it cannot be cleverly couched in such a way as to eviscerate or destroy its message. So you can't go, well, technically we had everything there, but it's so jumbled and confusing, nobody could understand. That's a violation of the law. You can't include superfluous or extra language that overshadows the required disclosures. So if the required disclosures are, say, 4 things and you put 24 things, well, you go, well, I have the 4 in there. Yeah, but the rest sort of overshadow. You can't even really see the 4. All right, it has to be clearly conveyed. Here's some other sort of language here from case decisions. It must be effective, conveyed effectively. And so they say the mere presence of the correct name in the notice somewhere does not suffice. So you can't just like put it sideways, on the letter somewhere and people are like, wait, it says Chase Bank. What does that mean? So requires the debt collector present information about the creditor in a manner the unsophisticated consumer can understand. So here's another decision from the 7th Circuit. Compliance demands more than simply including the information in some unintelligible form. And let me stop here and say, sometimes people go, well, why would a debt collector do this? I mean, if they're giving you the information, why would they make it in a confusing manner? Because it's not an accident. Everybody understands how to make these notices. They have chosen to do it in a confusing manner because that may discourage a consumer from exercising his or her rights. There are no accidents here. It's not like they go, oh, we just realized we sent out 10 million letters that are unintelligible. No, that's not an accident. This is all very carefully designed. So what does the 7th Circuit mean by unsophisticated consumer? It means somebody who, while uninformed, naive, or trusting, possesses at least reasonable intelligence and is capable of making basic logical deductions and inferences. And so they say, look, here's the problem for this debt collector. The form letter simply did not identify Chase Bank as a creditor. I mean, it would be easy if it said, the creditor is Chase Bank. We wouldn't have this case. But it did not say that. So now we're going to see this debt collector, client services, start making up all these excuses. Well, if you do this, if you sort of tilt your head a certain way, or if you know all this intricate stuff, then you probably could figure out. And the court's going to go, no, that's not good enough. So let's look at it. So here's one argument. The heading said regarding Chase Bank, somehow related to Chase Bank. And then it says it's been referred to client services for collection. And you could write to client services, find out the original creditor is different than the current creditor. And they say, well, look, that latter sentence raises possibility it could have been resold, but we don't know who owns it. It did not communicate clearly on whose behalf client service trying to collect the debt. Now, you can pay client services, okay, and that could imply client services is the creditor. Now, that's not a absolute requirement that you reach that conclusion. Of course, just say that's a possibility. So then they go, well, look, it turns out Chase Bank still owned this, But that does not insulate client services from claim it violates 1692GA2. Why? Because that required client services to identify the current creditor, Chase, clearly without leaving it to guesswork. And so then they're going to go through some analysis of prior case decisions where either it was clear or it required guesswork here. So here's a case where it identified both the original creditor and the current creditor. And then here's this other case where it talks about transferred from asset acceptance to some collection firm. And the debt collector says, well, transferred made it clear that asset owned it. And they say, we disagreed. And let's just stop right there. Transferred can mean a lot of different things. Does that mean, your doctor transferred the debt to a collector? Well, did they sell it? Or did they assign it for collection? Did they transfer it for collection? And here the court says, debt collector argued transfer made it clear. We disagreed because you have to guess who owns it. I mean, you might go, well, I think asset owns it. Oh, I think the collection firm owns it. We don't know. And so we reversed summary judgment, directed summary judgment for the plaintiffs, the consumers. And then they say unsophisticated consumers would understand the difference between transferred and placed. And this is funny to me. The court goes, with respect. Now, when somebody says to you, hey, with all due respect, they're about to insult you. It's kind of like somebody saying, I don't mean to hurt your feelings, but what do you know is about to happen? They're about to hurt your feelings, okay? So here the court goes, with respect, because we're about to say that basically you're an idiot, that supposed difference is not clear to the members of this panel. They're going, look, we're 3 federal judges, appellate judges. We write opinions on this stuff. And we're like, I don't know. What's the difference between transfer and place? And you, the debt collector, is saying, unsophisticated consumers should have immediately figured that out. They're like, that's nonsense. So they've not shown transfer and place have distinct meanings regarding ownership that are universally understood even in the debt collection business itself. And that would not be sufficient here. Then they say, well, look, we gave the account number. That's the ticket here. We gave the account number, so you should know. They go, well, listing an account number may help a consumer identify the origins of the debt, especially if it's an old account. The problem is the original account number says nothing about who owns the debt today. I mean, I could have a Capital One debt and, I get a collection letter 4 years after I default and it gives me the account number. And I go, oh yeah, that's a Capital One account. So what? I mean, I'm wearing black socks. So what? What does that have to do with, I don't know if Capital One still owns it. They've sold it to Portfolio, who sold it to Midland, who sold it to LVMV. I don't know any of that. Okay. It's just meaningless to say, well, you got the account number and that solves everything. It actually solves nothing here. And then, this is pretty funny. This third argument, the debt collector says, well, we gave you the mini Miranda, which means we don't own the debt. Of course, that ignores the fact that if they did own the debt, let's say that they're a debt buyer and they bought the debt, they still have to give you the mini Miranda. So that means nothing. Now, the court doesn't point that out. I'm just sharing that with you. Whether it's LVMV, Midland, Portfolio Recovery, all these guys claim to own the debt. They claim to have bought it. They have to give you the mini Miranda in their initial communication. So the argument is alerts it collects debts for other rather than buying it itself. And therefore, Chase Bank is the only creditor. So therefore, you must know that it was Chase Bank. And they're like, no. We've rejected that. And these are not logical points that we have to get to. And so what client services invokes is not logic, but guesswork. Because you're having to go, well, I think it might be Chase. I mean, I don't know. Okay. And that's the point here. So district court correctly observed that the 1692GA2 does not mandate the use of specific terms such as creditor or owner of the debt. And they go, yeah, that's right. It does not require use of any specific terminology. But that doesn't help client services, the defendant debt collector here. The act does not prescribe specific words. Here's what it does. It requires the debt collector to identify clearly, and here's the quote, the name of the creditor to whom the debt is owed. Now, this would be the idea of the current owner of the debt. Debt collectors are free to use words other than these chosen by Congress if the words will communicate the required information. What's that? The name of the creditor to whom the debt is owed. not past tense, but like right now, who do I owe on this? Who owns the debt right now? The plaintiffs are entitled to summary judgment as liability here because the letter did not clear that hurdle. Then the rest of this, you could read it if you wanted to. Not particularly important for our purposes right now. But here's the summary. Failed to disclose clearly the identity of the current creditor. Judgments reversed. Cases remanded further proceedings. So again, I wanted you to see this because it's a very direct opinion about when Congress said to a debt collector, you must tell the name of the current creditor. That means you have to tell the name of the current creditor, and you can't hide it or make it vague or ambiguous where consumers having to go, I don't know, maybe it's this, maybe it's that. You got to make it clear, effective for the unsophisticated consumer, or what a lot of circuits, including the 11th Circuit, would say, the least sophisticated consumer. All right, well, I hope that you found that helpful and interesting, and I will catch you guys in tomorrow's video. Okay, have a good one. Bye-bye.